All right, so we're being recorded. I will edit it
Okay,
if need to be.
perfect.
So what we want to do is just talk about a little bit about as is contracts. And the reason I picked this topic is just in my previous closing right now, I got this question. If I was representing the buyer, the sellers, um, it was an off-market property, so they didn't have a realtor representing them. So I recommended that they get an attorney, whatever.
Mhm.
But anyways, during the inspection period, I came back with a list of items that the inspection report showed up. And we were asking if the sellers would come back to us and say, okay, we'll fix these items. They came back and said, well, aren't they buying as is? Hence one of the questions that I said in there. I said, you know what,
Yeah.
let's address that and see where we can go from there. But before we start, let's talk about you, your firm, and what it is that you do and how long you've been in business. So go ahead.
All right. My name's John Hemenway. I'm with Bivins and Hemenway. We're a law firm in Valrico in the Brandon suburb of Tampa. We practice primarily real estate, business law, and trust and estates. We've been here since April of 2007. I have been practicing real estate for 15 years now.
So real estate law, deeds, and what else did you mention, John?
Business law and trust and estates.
Okay, so trust and estates.
Yeah.
What exactly does what does that entail?
So that's wills, trust, estate administration, which ties in a lot to the real estate practice. A lot of title issues come out of properties passing through probate estates or being held in trust. So that's a core part of what we work with as well.
Okay, awesome. Which could be a second segment that we can talk about next time.
Yeah.
So we want to talk about one question that I always get is whether I'm signing or agents are signing listing agreements or the buyer is signing the as-is contracts, that sort of thing. We always recommend as agents, if you're looking to interpret anything on this contract,
Mhm.
I suggest that you get an attorney. So let's start off with, why should buyers or sellers hire a real estate attorney, whether they're buying or selling?
So I've always viewed that as it's for peace of mind. For most people, they don't buy or sell a house that many times. The documentation can be confusing. It is always long. A real estate attorney can help the buyer or the seller understand what their obligations are, what their rights are under the contract. In the loan documents, they can help answer questions about the title insurance commitment, what the title insurance is even doing. So it's to help interpret all this legal language that will be put in front of you, what it means to you, and how it can help or hurt you.
You mentioned title commitments. So what is a title commitment?
So most transactions, it'll be required if you have a loan, will have title insurance. And that is basically an insurance policy that protects against someone else claiming they own the property or have a right to use some part of the property. So during the sale process, you'll get a title commitment. It'll be issued for the buyer to review. And that will lay out the terms of the proposed title insurance policy. So any exceptions to coverage, any things that the seller may have to take care of. If there's any kind of issues with their title, that will show what the seller needs to take care of, which is another area that a lot of times we have to provide some assistance in. But that will also show the buyer what the exceptions to their coverage may be. And interpreting that is another one of those areas where we come in to help.
An example of an exception would be?
The real basic exceptions are be things like the plat or the declaration. If you live in a developed newer community with a homeowners association, there will be an exception for all the items in the declaration for that association. So their ability to levy assessments, and but they could also have things like just the rights of the community to use the common areas and the parks and things. But you can find sometimes more unusual exceptions that are maybe, you know, potential, liens that weren't fully cleared that maybe, only encumber a little bit of the use. Probably the most usual kind of surprise exception is going to be some sort of easement. Not so much in a neighborhood, but particularly when you get out into older properties that are on some land,
Right.
sometimes there will be, an access easement for one of the neighboring properties that crosses over that property, and those are the kinds of things that are really most likely to sneak up sometimes.
And that's something that your firm and real estate attorneys in general would help resolve?
Absolutely.
Okay.
So that's something that we would help review, make sure that it can be plotted onto the survey, figure out what it does, figure out if it's still legally valid. Sometimes the title search will pull up something, and on that title commitment, there will be an exception that really doesn't apply, but it may not have been caught by the underwriter preparing that policy.
Right. When when a buyer or seller come together and they form an agreement, at what stage of the process should they involve a real estate attorney, whether it's the buyer or the seller? I mean,
I really think the earlier the better, but clearly I'm biased on that. But the really, I mean, from the moment of the contract, the agent will be able to help with, assembling the offer and negotiating terms on the contract. But when it comes to some of the more, uh, you know, intricate legal issues or just some of the denser boilerplate in there, that is something that, we can provide some help in interpreting. And we've had parties on both sides want, some assistance understanding what exactly, what is this term, what is an elevation certificate and why would I care? There's a whole
yep,
paragraph about it here. So those kinds of issues can come up, and then sometimes we're involved early for really customized addendums. If there's some really unusual terms the parties want to agree to, we can craft the document to do that. But really, any point along the transaction. So even if we're not involved at the contract stage, we've been brought in during inspections. Maybe there's concerns about what the buyer is asking to do during the inspection period, or maybe there's concerns about what the seller, won't allow, and whether that's okay under the contract. And then we get, to the title stage and the closing documentation. And again, that's review of a lot of, legal documents to really make sure everything lines up with what's expected and the parties are getting, what they agreed to.
okay. So two questions. Number one, are buyers and sellers allowed to use the same real estate attorney? Here, here in Florida, obviously they can't use the same real estate agent, dual
Right.
agency, but can they use the same attorney?
They wouldn't be able to use the same attorney. You'd have a conflict of interest as the attorney representing both sides. So, a lot of times, and what you're hoping for is everyone's interests are definitely aligned. One side wants to sell, one side wants to buy, and there's no problems. But the reality is, at any step during the process, we'd be advising potentially against the other party, or what your rights are, relative to what you can do with to the other party or require them to do. So even where there's really no open conflict, between the parties and the transaction is pretty smooth. The nature of the representation really is that you can't be advising both. It really will have
Right.
to be one side or the other.
Very good. Now, the agent is sitting with their client and they're signing these contracts, and then they'll turn around and look at me and say, well, what does that paragraph mean? Why are we not allowed to interpret contracts? And if we do, what would happen?
So there's a fine line where the Florida bar will consider non-licensed attorneys as engaging in the unlicensed practice of law, and so interpreting a legal document, uh, you know everyone has to read legal documents and has some amount of you know uh,
Input.
yeah, so that they're involved, but actually advising someone else on what a contract says, it falls into the practice of law. And it also practically is one of those issues that the agent may not want the potential liability. If that's not something that they are absolutely sure of or familiar with, they don't necessarily want to step into the potential liability of telling someone the wrong thing.
Right. Now, going back to the subject matter, what is an as-is contract?
So an as-is contract, that's the most usual one. That's what you'll typically see. An as-is contract basically says the buyer, as far as condition of the property, the buyer will have the chance to inspect the property to determine the condition and determine whether it's acceptable to them. The seller is not obligated to make repairs. There's another version of the contract you don't see as often anymore, just the residential contract. And that provides certain standards of repair for the property, even a budget that's pre-agreed to for certain repairs. And the seller is obligated to take care of certain repairs. The as-is, the seller does not have to deal with any repairs. The buyer can inspect, they can cancel the contract if they're not happy, they can renegotiate if it makes sense, if extensive repairs are needed. But the seller is not required to make the repairs. The seller does still have to disclose any kind of issues that maybe aren't obvious. There's always a disclosure obligation for a seller. If there was prior water damage or maybe issues like that might not be obvious from the inspection, but could be relevant to evaluating the condition. But again, there's no additional work they have to do that they're agreeing to do under that as-is contract.
Now, if they were to come to some sort of, so during the inspection period, they realize an AC needs to be replaced, there's an issue with the AC unit, there's a plumbing issue. You said that they can negotiate. So let's just say they agree at a price of, let's just say $200,000. Buyer estimates that it's going to cost maybe $5,000 to $10,000 in repairs. That can be negotiated. Now, is it best to negotiate it based on sales price, meaning a reduction in sales price? So what was it, 250 we said, so a reduction of 240? Or is it best to just have the seller make a concession at closing? Is there a difference there?
It can depend on the parties. The main difference would be if you adjust the purchase price and we're making a downward adjustment, that might might make the loan easier. Reduces the total cost of the loan if the purchase price initially doesn't have that element to it. Concession will basically come off of the closing statement, will come off these other charges, but isn't necessarily, depending on where the lender is involved, may not be something they're necessarily looking at when doing the initial loan. But at the end of the closing statement, the closing disclosure, when you sit down at the closing table, whether you've taken it off the top line or you've taken it out somewhere in the middle, it will ultimately come off the bottom line.
So what can typically go wrong? What in your experience have you seen can go wrong, whether it's on the buyer side or on the seller side when it comes to, as-is contracts?
So, it's usually misunderstandings. And we've seen probably a little bit of everything from, people that didn't understand that maybe the curtains wouldn't stay with the house to, we just closed and the window won't open anymore in the bedroom, and so where do we stand? We just signed 10 minutes ago and now this window doesn't open. So, the issues can kind of come up from a lot of different angles. Sometimes it's a contract question, if we're still under contract before closing. Sometimes it's a question going back to sort of those seller disclosure obligations, if there's some condition found later that's really a problem. But almost anything can happen, and so it's again where it's handy to have between your team of your agent and your real estate attorney to have somebody to walk you through what this means and what you can do.
Very good. Can a seller back out during the contract period? We've passed the point of the inspection period. That's passed. Now we're getting closer to the closing date. Can the seller back out?
The seller,
without repercussion?
Yes. So the seller can't. The seller doesn't have a sort of a free pass under the contract. The buyer during the inspection period can cancel for whatever reason. Once you get past that, even the buyer's locked in. The seller never really has that out. So if a better offer comes along, or they have some regrets about doing it, contractually, that's not a reason for the seller to break the contract.
Right.
So you're typically looking at some kind of negotiated exit, refunding the deposit at best case, but the buyer could potentially, and we've seen this from time to time, file a suit to try to force the closing of the sale.
Got it. So we're going to consider this as part one of hopefully a long series of videos coming from you.
Okay.
So do you want to give any last words here as we wrap up?
Well, I think for anyone looking to buy or sell a property, it's important to have a team assembled. You need an agent that can help you find the property or help find a buyer for you. You want a good attorney that can help you with the documentation and understanding your obligations. Good lender team, and the great thing about having a good agent and a good real estate attorney is they can help you find the rest of that team, all the people you may need to maybe fix up the house a little before you sell it, or to help do your inspections on the purchase end.
Awesome.
So always have a good team.
Very good. All right. Just want to thank everybody for being here today. And I personally want to thank John Hemenway for taking the opportunity to explain as-is contracts and how it helps and what all is entailed in helping buyers and sellers kind of dissect the different moving parts that are involved in a real estate transaction. So if you have any questions, feel free to reach out to me. And if you do have any real estate needs and need an attorney, John Hemenway is your best bet. And I'm going to leave his contact information here in the bottom. So again, please take a second here. If you found value in this, leave a comment, like it, share it, and look forward to our next episode with John Hemenway. Thanks a lot.